our Honorable Vice Chancellor Professor Ranveer Singh Sir, our guest of honor respected Professor Pendra Bakshi, our distinguished Professor of National Law University Professor B.B. Pandey Sir, and our respected Registrar Professor G.S. Rajpai, faculty and students of National Law University Delhi, and all the participants, a very good morning. Today we have gathered here for the two-day national conference on exploring critical perspectives in criminal law. This conference is organized by the K.L. Arora Chair in Criminal Law and the Center for Criminology and Victimology, National Law University Delhi. Now I request our Honorable Vice Chancellor Professor Ranveer Singh Sir to deliver the welcome address.
Also a distinguished professor at New Delhi and former Vice Chancellor of Delhi, the Professor B.B. Pandey, again a distinguished professor of New Delhi, and I see Professor M.P. Singh present here, many faculty members, Professor S.K.D. and Professor Vajpayee. Thank you very much everybody being here for this program, which is the National Conference on Exploring Critical Perspectives in Criminal Law. It is organized with the auspices of the Chair of K.L. Arora Chair in Criminal Law, and the chair is now held by Professor Vajpayee, and probably 2 days we will discuss some things. Before I pass on to the next speaker, very brief comments about the probably the present subject. Under the British law now, human rights and democracy for Indians were suspect, and social justice was delayed and denied at all stages, and so were the processes of justice, may it be civil or criminal. For all its ill, even today, the best thing is we blame our masters. That whatever is bad with us, it is because of our masters. Thank you. That way the Britishers at least have given us something that we, for all our faults and follies, we can say, oh, it's all because of Macaulay and all because of the people. And crime in India is on the increase. All know it. There's not a research point. Something I'm saying. Fear of crime and violence has affected the quality of life of people in India to a very great extent. And we see hardly any day passes when you open a newspaper, the first 2 pages are full of crime situation of all levels. The Indian legal system of criminal justice is a vast, complex enigma based on some of the most notable praiseworthy ideals, but then basically ideals remains ideals and nothing to happen. We are a country which is peculiar case of a soft and progressive state, and with stern stringent laws. We have very strict laws, but at the same time we are a very soft state. And the result is it is subjected to severe criticism, of course, for having draconian laws. As a result, neither the objectives of the strong laws is attained, nor the country's image is effectively protected from onslaught of national and international human rights warriors for violations. The fundamental malady is the absence of healthy social and cultural roots of our democratic institutions. And one very beautiful article written by Henry George in Indian Economic Congress. He said, when democracy becomes corrupt, the best gravitates to the bottom, the worst floats to the top, and the vile is replaced by the more vile. So when you face such a democratic setup, we observe that we do not practice democracy but gravitate towards democracy. With perceptible participation of criminals, their pervasive influence. The main idea of this two-day meeting, where we are going to discuss all these things, I don't want to speak much on this occasion, would be that we will be discussing all these issues, where do we start, and of course we don't have still anything to say where we do and where we have complete criminal justice prevalent in this country. With these remarks, I pass on to you, probably. to take up the mic. Thank you very much for being at NLU Delhi.
Thank you so much, sir. Now I request respected Professor B.B. Pandey, sir, to enlighten the audience on the theme of the conference.
Professor Bakshi, Professor Ranveer Singh, Professor MP Singh, and Professor Bajpayee, thank you very much for organizing this critical criminal law conference. We have been doing this exercise the last two visits of Professor Ellen Norrie. He has been doing very useful exposure to critical criminal law thinking, and all of you, he had a series of lectures earlier as a UGC fellow, and then later on he gave last year, and I think this could be used as a continuum of that exercise by Professor Ellen Norrie. But since we are trying to dig deep at the tradition of criticalism in Indian criminal law scholarship, we are trying to find out the reasons why, and we are trying to find out the issues that arise in not being able to take our criticalism to the level of metaphysics, metaphysical inquiries that Ellen Norrie, and some of which inquiries are still something very difficult for us. I would only say the reason for this is that criticalism is defined as thinking about examining the culture and literature by considering the social, historical, and ideological forces that are at work. And we have not been doing this, while as in criminal law, this is very important. Because criminal law, we have been teaching criminal law analytically. But to my mind, criminal law teaching misses the point when you do analytical teaching of criminal law. As a teacher of criminal law, homicide law, I have been talking of 26 shades of guilty mind. But that 26 shades of guilty mind may make it a little scientific, but it doesn't permeate down to the social level of inquiry. The inquiry becomes abstract and disconnected with the students. What is required is, and what is the bane? The reason is, say for instance, I wrote, say 25 years back, an article on control of labor through criminal law, vagrancy law studies in the light of vagrancy laws. And I was told by good friends, Professor Ponnuswamy was the editor of Delhi Law Review, Pandey, don't think this is one of the finest articles, this is just ordinary, we are publishing it. And that was his style of being critical. But I could not realize the value of that article till sometime after I had written it. Because, and I must thank Professor Bakshi, he gave me the reading of lead to Mark Neocleus's book, War Power and State Power, War Power and Police Power. He said police power is used by the state in a capitalist society by creating wars constantly against its citizenry, by making laws like vagrancy law. Oh, I said, wonderful, this is something which I had missed till I read War Power and Police Power. extensively, and he has said that this is the war that state constantly plays in civil society. War on marriage law, matrimonial laws, war on other fields, social evil laws, Child Marriage Restraint Act. Why Britishers chose in 1929 Child Marriage Restraint Act? Were they very kind to children of India, colonial rulers? They were not necessarily very kind. But through law, they were creating a kind of entering into family domain. Similarly, sati law, were they really kind and they had compassion for the satis? No, they were trying to, similarly you can say, triple talaq. Is it, are they really kind for that community? While you retain marital exemption for rape, you take Macaulay's words on marital exemption as gospel truth. We don't want to change it. In 2017, the Union government has filed an affidavit saying that we do not want to change the law. Some Western societies have changed the law. We do not want to change it. वाह बड़ी कृपा है आपकी, आप नहीं चेंज कर रहे हैं। जैसे कि बहुत अच्छी चीज है, उसको रिटेन करना है। We must retain this wonderful thing that is marital exemption. क्यों? क्योंकि we have in our minds a respect for law that is given to us. So criminal law is taken uncritically, uncontestedly, while as there are multiple areas in which criminal law can be contested. Criminal law can be critically looked into. हम criminalization of conduct, decriminalization of conduct, हम क्यों कोई क्राइम बनता है, क्यों क्राइम बना के Atrocities Act was made into a crime and now we are dragging our feet. Why are we dragging our feet? Can social evils be addressed through criminal law? That is a big question. And child marriage ho, ya untouchability ho, these are social evils. You're going to make law every time and you fail, the law fails. A death penalty for rape below 12. हर आदमी ordinance बना दो, जल्दी से बना दो. Now, do you want to really protect children? Do you want to really? So these are the questions that should ask, criticalists will ask. But we have been driving them under the carpet. Stephen Box says, crime mystification and law, that for most of us, most of the time, we have seen crime through the eyes of the state. State में जो कहा, that is crime, nothing else. So in our exercise, that is what I had requested Professor Bajpayee, that this critical theory should go into Indian problems that require a critical look, that require a critical examination. And if we can do something like that, it would be a indigenous criticalism or critical inquiry of criminal law, which is going to become one of the most important. I was telling Professor Purvi that criminal law is the foundational law. Unless you understand what lies under it, unless you understand the nuances of it, you will not be able to, because through criminal law, state creates wars against its own citizens. And if you permit that war to be created without understanding, without critically looking at it, they are Thank you very much. I will come when the topic is open to me. This is for the introduction. I thank the organizers, Professor Bajpayee and Professor Ranjit Singh, for having thought on having this critical criminal law conference. Thank you very much.
Thank you very much, sir. Now I request respected Professor Bajpayee, sir, the conference director, to say a few words about the conference.
Very good morning to all of you, and I take this opportunity to welcome the distinguished Professor Upan Bakshi in our midst, who has kindly agreed to come to be among us for this conference. I also thanks Professor B.B. Pandey. It is but for his guidance and constant engagement with this subject which made it possible today to have this very important event. And of course, Professor Ranveer Singh, the Vice Chancellor, when I discussed this idea, he readily agreed, and he said that this kind of program must be organized. I also have a lot of other people to be acknowledged. Professor S.K.D. Rao is among us. He has also, despite his engagement elsewhere, he has agreed because it is his area of specialization. And of course, we have many guests, Professor Purvi, who is of course a dear friend and a very constant support to the university. And I always had opportunity to go to Nirma, and wonderful person. And I have also to welcome Professor Rashmi from BEPS. She's there. Lots of guests, and a lot of people are being, deputed from the government organization, NCW, BPRND, NIA, lots of training institutions. I can share with you that we have received 200 plus applications for this, but I never thought this is a program which we can open for students and other colleagues. For that reason we kept it very simple. So still around 100 people would be attending this particular interaction. I'm so glad to share this information with you. Friends, very quickly in 5 minutes I'll just map you a small background to be able to give you a perspective of this particular event. It all began, as Professor Pandey said, that after Ellen's 2 important workshops, we decided to transform the LLM teaching of criminal law significantly. And resultantly, we have revised the curriculum, and now we have a full-fledged paper on critical criminal law. Probably the only university who is having this nomenclature in the country to have a full-fledged paper in the LLM, where we try to locate the sources of criticality which could be relevant for the studies and research in criminal law. So first challenge was, because when we look back in 70s, CLS movement started, critical legal studies movement started. But I think a lot of writing is indicative of the fact that CLS could not reach to criminal law as such directly. So you will not find much except the remotest discourse that I can map was the Devlin and Hart debate in late 60s after the Wolfenden Committee report, when the issue at the discussion was whether the criminal law should try to regulate the moral issues or not. That was the key. So Devlin started that yes, as long as it affects the society, it is very much within the purview of the criminal law. He was responded and criticized by H.L.A. Hart, who has taken a different position, and he had reservation that the criminal law should have limits and privacies of the people should not be influenced and affected by the reach and operation of criminal law. And while that discourse is very well documented, we often discuss in the class. But subsequent to that, many of us are aware that Fenberg has written the monumental book on the moral limits of criminal law. That has become a kind of signature book which has mapped the real issues. And since then, probably this moral versus legal debate in criminal law has started. But probably all these things are missing in the curriculum of criminal law at all levels in India and elsewhere. I find how come that debate could stop there and would not reach to the teaching and discourses within the teaching of the criminal law. Therefore, criminal law continues to be normative in most cases, and probably, as Mr. Pandey said, we have not probably located the sources of criticality. So in these days, what we are trying to map, what are the sources of criticality which could be located. I'm also referring, I think these are some important pointers, though we will discuss and debate later. Allen's entire focus was to highlight the the historical continuities in criminal law, and he said that the contradictions are something which define the criminal law. Though the people, in his famous book on crime, reason and history, he said in the first paragraph of the book, and first chapter of the book, that the contradiction is not something which should be done away with. Because he said what the conventional criminal law scholars says, and they said the rationalizing enterprise of criminal law is something which should be identified, to which the Allen has criticized. He said contradiction is the characteristics of criminal law. And he has taken the matter to the level where he said the dialogical debates in criminal law in terms of discourse. And at places he appears to be saying that criminal law is a language, it's a communication, because it is always in relation to others. So how others take it, because Stephen Boxer has referred to exactly the same context. And also we find that a very important paper which was written by Paul Butler in the backdrop of a very famous Gideon versus Wainwright in 1963 in the US. That was a watershed in the history of American criminal justice system. And through this paper, the Paul Butler, highlighted that poor people lose in American criminal justice system. That was his title, remarkable paper. So I think the criminal law critique has started from 70 itself in the US after all these writings, which have reached to a different level. And very late on this 12th of June, I was in City University in Hong Kong. Anthony Pemberton is a professor of victimology at Intervict Tilburg, Netherlands. He made a very, I would say provocative presentation, which is very pertinent to understand the criticality issues in criminal law. Unlike the popular discourse on justice, he has presented the theory of injustice, which is something very interesting. And then he said so lots of concept he said we have to see very independently, and he was able to show that injustice is not the reverse of justice, it is very independent notion which has to be looked. So in criminal law discourse, critical criminal law discourse probably, we take up these ideas from different locations and try to approach criminal law from the standpoint of criticality, and therefore this entire discussion of mapping the scholarship. In this workshop or in this conference, we will also try to take you to the emerging scholarship in the field of critical criminal law through the writings and thinking and contributions of a number of important critical criminal law scholars who are contributing. And probably that would provide you some idea to revisit the Indian criminal law especially. And I also refer the last issue, Mark Dover, he has said a very interesting point, and which is also true in India. He said somehow the criminal procedure in India was subjected to a lot of scrutiny from the viewpoint of constitutional touchstone. But somehow the substantive laws have not been scrutinized substantially even in Indian context, and this is true of most jurisdictions. And so these are some debates which are around the scholarship of critical criminal law. And probably when we look at, so in this paper which we teach at LLM, we try to map all these viewpoints, the normative discourses, institutional discourses, social discourses, feminist discourses around criminal law issues. And we'll try to make a fresh reading of the provisions of criminal law from these angles and these perspectives. So I'm hoping that the topics that we have slated for discussion would provide a substantive framework for reconsidering the criminal law in a fresh way. Because I always feel when I teach in the class, most of the time I would say, why of the criminal law is always missing in the class. And if you ask to why of any criminal law provision, probably it takes you to a jurisprudential discourse and a philosophical discourse. And the very foundational, work on Oxford Handbook of Philosophy of Criminal Law, John Day and Donnelly. They have started underlining this particular matter, that how the criminal law teaching from the viewpoint of ethical perspective is possible. And therefore, through this conference, we'll try to approach some of these topics. But friends, I would request you to please keep the perspective of this entire discourse in mind, because we are not here to describe anything. We are trying to approach the issues from a very different, and what are the alternative arguments. This is very important. So I am hoping that in all these 6 sessions we are having throughout the day, today and tomorrow, 6 sessions we have, and we have some important speakers to speak on various subjects. I am sure that you will be benefiting yourself from this occasion. Try to participate as well as possible. We have not kept elaborate paper presentation, mechanical, and this process, rather leaving a lot of room for discussion. And I hope that you all will try to make use of this space. Meanwhile, I also welcome Mr. V.V. Sharma is from ADG in Madhya Pradesh. Thank you for joining today. So welcome all, and today we will continue after this session. After Professor Bakshi's address, we will go for group photograph and tea, and then we will reassemble in this hall, and we will continue. Thank you for you.
Thank you very much, sir. Now I request our guest of honor, respected Professor Upendra Bakshi, to deliver the inaugural address.
Thank you for this very kind invitation. So the first point, Professor Ranveer Singh, Professor Pandey, distinguished vice chancellors and chancellors of the various universities, and distinguished participants, as well as distinguished people. I stumble, and dear friends, because I divide humanity into 2 spaces. Those who are distinguished and those who are distinguishable. And I think I am in the second category. So everybody is distinguished and everybody is interested in criminal law. I'm very, very, very impressed. A word of apologies, and that is a word of congratulations. Word of congratulations is the following: Professor Bajpai, critical thinking per se is welcome on any aspect of law. And critical thinking does not merely involve, or very rarely involve, trading of half-baked opinions on criminal justice system or any system. Critical thinking implies and entails Herculean labor of arguing against yourself. Not arguing a position, but arguing against yourself. That's a very difficult job. So I wish you a very nice spread of areas and topics, including women, including safety of women, including sentencing, and a large number of other things. And a word of apology is precisely for that. My body would not hold for 2 days. I tried to sit as long as is humanly possible today, but you will excuse me if I have to leave after some time. So I'm very certain that you will come up with a lot more critical perspectives than the earlier generations have, and wish you Godspeed in that. Now I want to not give a inaugural address. I'm not used to doing that kind of bakwas. But I do my own bakwas, and the only question I'll ask you to lift it up is one, but it has several facets, so it take a little bit of time. It's saying very little. I'd say little, but I take some time. So do forgive me. Also listening to Professor Pandey and Professor Bajpai, I'm very glad that this was their idea and Alan Norris' idea. Critical outlook is built into criminal law system. You don't have to import it. Because when you look at classification of crimes in the Indian Penal Code, crimes against persons, crimes against property, crimes against state, etc., you have to ask the question, you stumble on the question, why are crimes so classified? What is the difference between a crime against a person and a crime against a state? What ideology underlies the classification? So criticality is built when you ask questions like why certain things are made into crimes against this and crimes against that, crimes against that. Why the state has force monopoly. Why is the public prosecution entrusted alone to safeguard society against crimes? I know from movement person, I know how running this one there to struggle and very high for many people that they think prosecutions for crimes against persons are a monopoly of the state. Why should prosecution be a state monopoly? Why can't the high courts and Supreme Court ultimately permitted some of us at that time to speak on behalf of our victim, but the prosecution was in the hands of the state. I can understand force monopoly, but I can't understand why prosecution is monopolized by the state. Although we try force and independent prosecution, etc. So there are a number of questions that inbuilt into the very administration of criminal justice. Some I forget the name, they might be able to supply. Somebody in America wrote a book which made a profound impression on me some 10 years ago or 15 years ago. I'm a pretty historic person. I remember a lot. But this was a book, its title is Punishment is the Crime. Normally, crime is that involves punishment. But the judicial process, I will get back his name, punishment is the crime. The criminal law is not in relation that you establish in crime and punishment, but what is punishment? I don't think we know that, and that's the question we should ask. What is punishment? I'll come to it after that. So I think it's very important, and if you're doing, and before I come to my question, the other thing that arose in my mind while people were talking about criminal law is that critical criminal law scholars have to make up their mind on a fundamental issue, I think. And I hope you will enlighten me on this. The fundamental issue is this: whether criminal law is an expression of state power or whether it is an articulation of societal values. You have to make up your mind very early on what it is, and depending on the way you jumbling up will not help. Jumbling up is not critical thinking. You have to be very clear in what line you take. I think it's very important for criminal law scholarship to, if it is articulation of societal values, whose values are societal values? It's something that are women's values, societal values, are children's values, societal values, are mentally challenged people's values, societal values, or society is the dominant caste, the dominant power in society. That is the values of those sections of society which are constitutional elites. It is their values. Whose values are society's values? So Professor Pandey talked about untouchability, atrocities. Some other people talked about other law being represented. We think that law is ineffective because we put so many things that law cannot achieve. I mean, quite right. So the question is, are you studying criminal law from societal values perspective? Are you studying criminal law, or are you going to study the law from the point of view of state power and pathologies of power? It's a very important question, a threshold question. I'm guilty. Fortunately, nobody takes any notice of it. I'm guilty of having raised this question I wish to discuss with you briefly. The question is, does India have a criminal justice system? I raised the issue in a book called The Crisis of Indian Legal System, which I have not read since I wrote it, and which you obviously haven't read because it's a book on criminal law. But it is nothing but criminal law. And it is now what we call critical criminal law. So there's a book that talks about delayed court, that talks about prisons, closed prisons and open prisons and closed mines, that talks about constable as a colonial minority. I speak from memory, it's dusty. It's a book about criminal justice system, and it raises this question. And that was 81. So if you're interested, it's on the web, you can look it up. I was asked to do a second and revised edition of a book called The Crisis of Indian Legal System. And I have said, no, how can I write a book called The Crisis of the Indian Legal System, and I write a second book which is revised and expanded edition of Bowen Pandey, and I thought about bringing out a fresh edition, and we both went duly cold in a short time. But the book is available. I don't know to speak about it, I don't remember what I written. Basically, I raised the question, do we have a criminal justice system? And is it civilized? Now, question about system, very briefly, a system is not merely, according to the systems theory, a sum of its parts. A system with integrity is more than a sum of its parts. A system always involves communication with the other system, which forms the environment for the given system to work. Take a body. Any elementary anatomy book will tell you that the body, human body, has 5 or 6 systems: endocrine system, reproductive system, digestive system, cardiovascular system, nervous system, and a body comprises so many systems. And what is important about systems is intercommunication. One system providing a reproductive system, one system providing an environment for another system to work. If each system is autonomous, sometimes here of subsystems, all that. The systems theory bare bones. If you bear in mind only the elements of idea of a system somewhat clearly, then you can meaningfully tackle this question. I say that we have not developed a criminal justice system. My friend, very much, Krishna, ran away with the idea and call it administration of criminal injustice system. And the judgment you will find that it's not administration of criminal justice, but it's administration of criminal injustice. That was his way of putting it. Now why do I say? First, we have a rival so-called system, which I described in a book, I think. In fact, as a chart called PDS, Preventive Descendant System, incarcerating people without imprisoning them, not trying them. And it does most of the job of criminal justice in other societies. Article 22 succeeds Article 21 in the Constitution. What's Article 22? Article 22 is life, liberty, protection, etc. not to be deprived without procedure established by law and legal. And the Constitution says in Article 22 that state can preventively detain you for life. Now, what kind of liberty has our Constitution guaranteed? It is not an exception to 21. It's not a reasonable restriction. It's a parallel system. You have liberty and you can be preventively detained to the state justice in that way. and very few scholars of preventive detention. And I think therefore, we have a large number of criminal law systems. Systems into what I say quotation mark. One is the state system, which has two wings, two branches. One is the criminal administration of justice system, CJS, and other is PDS, preventive detention law. And they two never meet. Now why don't we, if our federal government, study this? Now, that's not my point. Number one is there is no intercommunication within the legal system so far of tracts and rights. For example, nowhere in India do I see on the table of the Chief Justice a chart saying how many prisoners can a prison accommodate, sanctions set, and how many people the prison actually holds. A weekly chart, a fortnightly chart, a monthly chart. Now we talk about sentencing discretion. You haven't a clue as to how many people are in a particular jail or some jail, and you keep on sentencing them to life imprisonment, 4 years, 5 years, 6 years, 2 years. The system of administration of judging has no communication with the system where it sends people. There is not a system. There is chaos masquerading as like with a number of justices, Chief Justice. And they said, you're right, we must do something. Instead, what does the Chief Justice of India do? The moment they are spawning, they rival with their predecessors in saying that the Indian legal system is collapsed. Now, if Indian criminal justice system is collapsed, whose fault it is? Who is to look after the fact the system should not collapse? The Chief Justice of High Court and of India. So I think any other civilized justice, criminal law, administration of criminal law. I was in the state of New South Wales in Sydney, I was teaching, and in 60, before we were born, we were there. But I went for some reason. I was charged with a criminal offense. I was a teacher. Sydney Harbour Bridge was recently constructed. And my students and I went with a placard, and we stood in the pedestrian area of the Harbour Bridge and said, please slow down, radar ahead. That only placard we said. We thought we were assisting the safety experiment. The New South Wales police charged us with obstruction of performance of police duty. And I said, I just first a second year teacher, that's just gone to Sydney. My first teaching experience, and I said, why are you obstructing police duty? Now, police had the idea that you will obstruct them. Idea was to catch errant drivers, to punish them, to fine them, to take away the licenses. And we, according to them, rightly so, we are obstructing. We asked them to slow down. If safety was the motive, so I requested the magistrate, I said, what a charge. Nothing was further from our mind, and you are strapping upon us bench to come in open. But that's another story. It took a long time to settle the matter. And I was ready with my bags because I was invited. I could be deported any time. But then I would engage this story just now. But in the process I found out that the Sydney magistrate every week received the intake figures and the holding figures from the New South Wales prison. Now, if a magistrate, that you are discussing sentencing, so kindly bear in mind, why can't you do it? We have not done it with independence. And we excel in this, where there is no such thing. That's my evidence one. Then secondly, the state advocate attorney, including advocate general, rely on state law affidavit. Practice of law, which you are about to embark, some of you, consists in saying naked lies on solemn oath, which you know to be lies, but you are paid to lie and you lie. And misleading the court is an offense, and an advocate is an officer of the court. But success in legal practice depends on the amount of lies you can tell on this false affidavit to a state attorney. I speak from experience of thing I founded called social litigation for 10 years. And I've developed a gift of reading state affidavits within 20 minutes and saying where they are going. I won't be ready. It's art. I'm willing to pass it on to you. Fish your pride. In Kalahandi petition, there was the chief minister, forgive me, Vice Chancellor of Orissa. Hey, Krishna, forgive me. There was a man called Janaki Vallabha Patnaik. I don't have the Lord's name, but that's Sonora's name. Janaki Vallabha Patnaik and his state secretary filed an affidavit which said there are no deaths due to starvation in Kalahandi. And then the affidavit said, however, and always watch the however in state affidavit. That's where the clue is. There are some deaths in Kalahandi, but they are due to, hold your breath, progressive malnutrition. Now what the hell is the difference between progressive malnutrition and starvation? What is the difference? If you wake up, although lunch today is Mr. Bajpai, Professor Bajpai, progressive malnutrition is Russell Guru, or it is starving you, but maybe opinions of the department lawyers are paid to defend the indefensible, so obviously you can defend it. But this, I can't go into that. I've already exhausted my time. So, first thing is, Hussain Rana Khatun, Islamic right to spirit trial. Kapila Angorani was very too much work. So she sent me, he said, Hazaribagh prison has filed, because Bhagwati, Justice Bhagwati and other judges ordered Hazaribagh jail to give a prison census at our asking. We requested, and the Supreme Court said yes. And we got a prison census up to this big. And again, idea of reading state documents, completely false, I knew that. It was 74, 75. What did he say? Every sixth person was Ram Krishna Paramahansa. And every 12th name was Vivekananda's circle. And the students were helping me. I tell you, numbers 6 and 12 you watch, and consistently they put everything down. Because they did not know which prisoner's name they had in the system. And the magistrate ordered that they should be detained and under trial. They don't know how many people prisoners in hold because they have no idea. So, talking about system itself is a misleading exercise. If we tell our students that you have a criminal justice system, we are wrong. We don't have a criminal justice system. The task is how to create a criminal justice system. How to create a just criminal justice system is a different matter altogether. But how to create a human rights oriented criminal justice is also a different matter. Or how to create a state-oriented criminal justice system, that is also missing. So I think we live in a cloud cuckoo land when we talk about criminal justice system. Take another example. An elementary principle of civilized criminal justice system is what? Here I go back to the concept Roscoe found. Roscoe found a famous notion of dual postulates of civilized society. So what's the civilized administration of criminal justice? It's a system interacting with all its parts. only take in jail, but it doesn't take police either. It doesn't interact with open jails. It doesn't interact with custodial homes, Nalini Ketan. That is, don't have the time. Their function is to find a criminal, catch a criminal, sanction, and put him in jail, give him punishment. But first lesson of world civilization is troublesome, I confess, after Hitler, Aryan civilization, and so on. It has come back again. There's some normative value. Colonialism made the world civilization absolutely discredit worthy. But bearing this point in mind, there is some sense in talking about civilized criminal justice system. What you would not want to be done unto you would not do to others. That's what Mahatma Gandhi said, and many other people said. What you would not do to yourself, you would not do to others. That's civilization. Let's just stop there and think. Now, a normal system of criminal justice does not treat the law as a program of revenge. It treats law as a dispute settlement mechanism, as a mechanism for punishment for stated law. Law is not a means of persecution. It's the means of prosecution. A normal civilized justice system of criminal law knows the distinction between persecution and prosecution. And when that difference is erased, everything is erased. You don't have system, but you have criminal laws. You have the law of the dominant, that's all. Very thin line, admittedly, between prosecution and persecution. Now you find out whether this is self-independent. We know the difference. Investigation, CBI, SIT, think of anything, prosecution. What is the difference between a prosecution and persecution? Law does not allow persecution, ought not to allow persecution. Take a second maxim. One is sent to jail as punishment and not for punishment. You are not imprisoned. What does the IPC say about imprisonment? Loss of locomotion, loss of liberty to move around is taken away. These are notion of punishment. Nothing else is taken away. And look at Lily Thomas in 2006 or 8 Supreme Court. Oli Nariman argument, many other cases. What does it say? You can't vote if you are convicted. Why? Why should, under what law do you take away my other rights? You can take away my locomotion. There's a theory, Pandey will tell, of incapacitation of something. That a prisoner is temporarily disabled from moving around. Yes, fine, that's the punishment. But I'm not sent to jail to get rotten food, to get no health care, to get no clothes to wear in winter. None of that is authorized by penal code. But what do the criminal law teachers tell you? Or you do it when you study the Metropolis Jail Manual. We only stop and start with crime and punishment. Nobody is sent to jail for punishment. In a civilized system of law, you are sent to jail as a temporary suspension of the right to move. Anything else, remember Lady Portia and Merchant of Venice. She said first woman law and literature and woman. What does they say? A pound of flesh, you can have it, I've contracted with you. But you can't shed a drop of blood. when you measure state progress against a puny individual, you have to be a strict legalist. You have to be an ethical legalist. Every word the legislature uses matters. You can't take away a citizen's liberty by a broad interpretation of the statute, by a broad interpretation of whatever I think is pertinent. I openly asked Justice Bhagwati and his brother in the Supreme Court after Usanara. I said, I want, because Kapila said, I will not argue to have a lawyer. I said, I will argue for you. I said, I want to intervene an order from the court. Supposing I had served a pre-trial detention and the trial did not come up for 6 years. And I was tried after 12 years and I was held not guilty. So I said, issue me, Supreme Court, issue me with a coupon to commit 12 years worth crimes. But I would not be punished for those crimes because I already served 12 years. Advance imprisonment for a crime which I had not committed now, that's preventive prison, advanced imprisonment. So Supreme Court should issue coupons to prison, not try to speedy trial. And I never seen in my lifetime, human or in my lifetime. There is no such thing. It's all right to write papers on right to speedy trial, compare law, Australian law, American law, nonsense. It's not research in my opinion. Normative research, I bet. You can do it. No harm. It does help anybody, it doesn't hurt anybody. So you can do that safe research. But criminal law is unsafe, invites unsafe, critical criminal law invites unsafe research. You don't have to mark us, but you have to take some risk in research. All right, so I think we don't have a criminal justice system for this reason. Fine, my final point, and I don't have the time, is residual rights I already talked about. There is a thing called Innocence Network in India. And there's a book written by Manisha Sethi on Kafka Land, which is paperback. It was UK. Something else in Kafka Land, where she and the Dhamma Media Teachers Solidarity Association has done a report of people who were put by the special branch of Delhi police for treason or traitorous activity, terrorism, not treason. And she documents 21 cases and released that book. She doesn't say, they don't express their views, they just document the judgment. 18 of them were released after, in a duration of 11 to 15 years. They grew up every day. But they were released by the High Court. And there was no substance in the prosecution. No compensation. Why? Whose fault it is that I am deprived of my liberty because you take time deciding the matter? What kind of system is this, if it's a system? That you speak after 15 years, 20 years, until then I rot in jail for time that I have to say I am not committed? When did Upar victims in the civil law matter get their compensation from the Supreme Court? And the symbolic gifts of punishment. We think of Bhopal victims, now second half generation. Think of 84, 2002, go back to Delhi massacre. When did they get compensation? So one must ask this question. I know that delay is a very complex matter. I was just telling Ranbir Singh and other friend of what the incoming Chief Justice of India said, if the no supersession takes place, and if the outgoing Chief Justice recommends the incoming Chief Justice, Gogoi, Justice Gogoi, was there a book release function last week. Press has not reported it, only one paper is reported. I read papers because news is nowadays very scarce of what happens in the country. So he said, Gogoi, Justice Gogoi was chair. He did his book written by Kailash Vidyarthi. And Kailash said there is a textual emergency as far as children of India are concerned. And he said, and the Justice Gogoi in the address said, no, I won't go so far as to call it a textual emergency. But I would say I'm in a state of mortified shock. Okay? And the second thing that Kailash said was it take 100 years for a POSCO trial and appeal to fructify. Ultimately, justice to be done to children. By which time they were grown up, or they were dead even, I don't know. And Justice Gogoi said, no, 100 years is too much. I think 50 years is okay. So we specialize in intergenerational justice, not intragenerational justice. So I tell when I talk about environment and sustainable development, I say you Westerners, आपको पता ही वर्ल्ड पे क्या हो रहा है. हमारे यहाँ तो आज ग्रैंडफादर ने एप्लीकेशन डाले कहते वो ग्रैंडसन ग्रैंडडॉटर को मिले या उसका इसके आगे पीढ़ी में पता नहीं मिलेगा नहीं न्याय मिलेगा तारीख मिलेगी न्याय नहीं मिलेगा. A commission of inquiry on Ayodhya took 20 years to report. And my friend, Justice Ranjan Naraman, in the Ayodhya case, says, I told him says to people, to Lucknow court, consolidate all the proceedings, do it within 2 years, no day-to-day hearing. Just day-to-day hearing. Try to appeal, of course. Try to process, of course. So we believe in a kind of jurisdiction which is not merely intergenerational, but which is celestial. That is, even if the accused are dead and can't be prosecuted, the fact that you committed a crime will be recorded. You can't do anything about it. For God above to take care of the fellows there. So we talk about prisons and all that. Our prisons are also. I was asked in Hyderabad to talk about independence of judiciary by young lawyers, the 35th anniversary of the Young Lawyers Association. And all the High Court judges of Andhra Pradesh were there. And I said, independence of justice, independence of judiciary, how can I talk? Justice Majumdar was the chief. I said, chief will bear me out. That in Andhra Pradesh, more than half, if not all the justices are appointed by Satyasri Sai Baba. Not by president. The thing said now, maybe and nothing against Babaji. But that's the fact of it. I know it. I've done it about it. And therefore, I said, I can only say in India we've developed 3 kinds of adalats. One is custody, adalat for stage 4. Second is lok adalat. It's also state courts now, but also agencies, private agencies done. And the third is parlok adalat. So parlok jurisdiction is what is practiced in the name of criminal justice system. The only thing is the accused is dead, he or she cannot be accused. But will proceed with क्या कहते हैं आजकल का खास दस law will take its own form. When? How? What? Is the question. When will it take its course? How will it take its course? What course will it take? This is the requirement. Not go will take its own course. We all know it will take some course. But delay is a very, delay is a very much told you. Delay is a very difficult matter to study, and I urge you to study. Whenever there is a norm, sometimes it will be taken wherever it is decision. As prosecution, as judging, or as lawyer. So when I had to study the problem of delay in 1976, I said, I don't know anything about it. I still don't know anything, but I did make my sums. I did pilot project. And I found out in 3 locations, Allahabad, Delhi, and something else, I found out that for forgery it takes 7 years and matters end at the High Court. So I said anything below 7 years, beyond 7 years, is delayed. Murder at that time took up to the Supreme Court 3.5 years maximum at that time. Not a good day. How long the murder trial last time? Just the final plea. We don't know. Criminal law, 30 of hands of decades. I know, but I won't tell you. So to find out for yourself. So that's the problem. The problem is delay, measure delay empirically as to what different offences take different time. Finally, there is no prosecution. It doesn't take time at all. Cases are filed. You forget it is offense. Everybody is forgotten it's offense. Some take 7 years, some take 4 years, some take 5 years. And from that plus is delay. So you take account of the how courts work. Now, therefore delay occurs is inbuilt into the system. Because whether it is collegium or it is executive appointment, we have always worked half of the sanctions less than independence of judges. Always less than half, sometimes generally the average half. Who is responsible? In the tax book said lawyer caused delay, judge caused a 6 classification. It's all right for that book. But now I ask the question, who is interested in speedy justice in India? Which section of constitutional elites is interested in speedy justice? Now, if you have half the sanction strength of judging, delays will be 2-4, not 3-4. Not surprising. So who has vested interest in delays in criminal justice system? I leave that question with you, because after 70 years, at least one is entitled to raise this question. Without being political, everybody knows. I'll tell you one story and then I'll sit down. It's unfortunately about a woman, I'm a feminist, but there's a little girl called Esther. And Esther asked her daddy and mommy, and they're very free with the girl, said, why do I have a brother to play with? They said, darling, we'll think about it, we'll talk about it later. And they both decided on answer that Esther back down. They asked a very pertinent question. And they explained some kind of biology. Esther was about 2.5 years. They explained that it takes time to have a brother, to us. So she said, how much time? It takes about 9 months to be frank. And some extra time more, sure. She said, did you understand it with the child? She said, Swami, if that's the problem, why don't you put some more men on the job? And let's be right about that. Now, delay is not a question of putting more men on, although I talk about deficit of judges and so on. Delay refers also to quality of justice. It's not just a question of putting more men on the job. So don't give me that answer again of Esther Chavez. I'm very fond of Esther. I've become very fond of Esther's of the world ever since they reply. A question that she asked. It's a question in a sense of putting more men on the job. But that wouldn't solve the problem today. The reform of legal profession, reform of judicial profession, reform of vexatious litigation, reform of using law as a means of prosecution, that people go to court. So many kinds of reforms should do to prevent the situation today. Oh, I'll end here now, and good luck to your deliberation.